Well, hello Dragons, and welcome to this instructional video for Lesson 12, Part 2 of Flexible Framework. The main idea behind this civics lesson is the Supreme Court's role is to apply constitutional principles to a changing society. With that in mind, by the end of watching this video, you'll be able to describe the Supreme Court's role in applying principles of the Constitution to a changing society, summarize the struggle for equality and an end to segregation in the United States, contrast the two sides of the debate over affirmative action, and explain how the principle of equal protection has affected the rights of women. Now that the outcomes for this lesson have been shared with you, let's get started. Amendments enable the Constitution to change with the times. Now you will take a closer look at why, in fact, very few changes have been needed. The framers realized that specific instructions for running a government in 1787 might not work years later. By providing general principles, they gave later generations freedom to fill in the details. In this way, the Constitution does not have to be changed to meet every new issue the government might face. You may be wondering, if the Constitution does not spell out in detail how to follow the principles, who makes sure that they are being followed correctly? This is where the courts, especially the Supreme Court, enter the picture. The Supreme Court has the final say over whether constitutional principles have been correctly followed by government officials and other citizens. By deciding whether a certain action violates the Constitution, the court makes that action either legal or illegal. Supreme Court decisions must be obeyed, not only by private citizens, but also by the President and by Congress. However, a court decision is not necessarily permanent. It may be overturned by an amendment that changes, removes, or adds a constitutional principle. For example, the Dred Scott decision was overturned when the 13th Amendment abolished slavery. A decision may also be overturned by a later court decision. New evidence or new ideas may lead the court to change an earlier interpretation of a constitutional principle. How has the Supreme Court applied broad constitutional principles to a changing society? One way to answer this question is to see how the court's interpretation of one principle changed in the course of several important cases. A good example is the 14th Amendment principle that each state must provide citizens with equal protection of the laws. Equal protection does not mean that everyone must be treated in exactly the same way, but only that people must be treated fairly. For instance, a bank does not have to lend money to every customer, but it must be fair in deciding who will receive loans. It may base its decision on a customer's ability to repay the money, but not on a customer's racial background. Denying a loan to a person because of his or her race is, of course, an example of discrimination. Human history has been scarred by many forms of discrimination. The following cases focus on two forms that have been particularly common: racial discrimination and discrimination against women. As you listen, think about the Supreme Court's important role in applying the general principles of our Constitution to these situations. The principle of equal protection was originally intended to prevent states from denying rights to African Americans. Over the years, the court has interpreted the meaning of equal protection in many situations that might involve racial discrimination. Although the 14th Amendment had given blacks citizenship, many states passed laws requiring segregation, or separation, of blacks and whites in public places such as hotels, schools, restaurants, and trains. Did segregation violate the principles of equal protection? The court faced this question in 1896 when it heard a Louisiana case involving Homer Plessy, a black man who had refused to leave a whites-only railroad car. Plessy argued that the Louisiana law requiring segregation violated his right to equal protection. In a famous decision, Plessy v. Ferguson, the court ruled that the Louisiana law did not violate the 14th Amendment, as long as the cars for blacks and for whites were of equal quality. For more than 50 years after the decision, This separate but equal standard was accepted as a justification for laws that segregated blacks from whites. Not everyone, however, agreed that separate but equal facilities truly guaranteed equal protection of the laws. Many schools and other facilities for black Americans were not as good as those for whites. Furthermore, even when the facilities were equal in quality, the fact of being separated by law made many black Americans feel that they were treated as inferior to whites. Could it really be said, then, that they were being treated equally? By the early 1950s, many Americans were questioning the fairness of segregation. Among them was Thurgood Marshall, a lawyer for the National Association for the Advancement of Colored People, or the NAACP. He and other NAACP lawyers brought before the court several cases involving facilities that were segregated but equal in quality. They knew that such cases would force the court to decide whether separate but equal facilities truly represented equal protection. At the center of one of these cases was a schoolgirl from Topeka, Kansas. Linda Brown was about to play a role in overturning a Supreme Court ruling that had permitted segregation for over half a century. Linda Brown lived only 7 blocks from a school for white children, but by law she was required to attend a school for black children 21 blocks away. Linda's parents thought she should be able to attend the neighborhood school. Therefore, they took the school board to court with the help of the NAACP. In arguing the case before the Supreme Court, Thurgood Marshall presented evidence that separate schools had a harmful effect on both black and white children. Black children were made to feel inferior to whites, he argued, while white children learned to feel superior to African American children. Therefore, Marshall concluded, separate but equal schools could never be equal. All of the justices on the Supreme Court were convinced by Marshall's reasoning. The court agreed that segregation of African Americans creates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Separate educational facilities, the court ruled, were inherently, or by their very nature, unequal, and therefore violated the principle of equal protection. The decision in Brown v. Board of Education of Topeka overturned the decision in Plessy v. Ferguson, and made all segregation laws unconstitutional. Thus, it is a significant example of how Supreme Court rulings can keep the Constitution flexible. The court's ruling gave a powerful constitutional weapon to Americans who were fighting racial discrimination. Spurred on by the Brown case and by increasing public pressure during the 1960s, Congress passed a series of laws, known as civil rights laws, to guard against racial discrimination. However, these laws could not undo the effects of years of discrimination against African Americans, Hispanic Americans, Asian Americans, and Native Americans, particularly in the workplace. Over the years, many companies have discriminated against job applicants because of race. In these companies, the racial background of employees has not reflected the mixture in the local population. For example, a business whose employees are all white, even though half of the workers in the community are African Americans, Hispanic Americans, and Asian Americans. Starting in the late 1960s, as a result of the Civil Rights Movement, the government worked to correct the effects of unfair hiring practices. It required companies to take affirmative action, steps to counteract the effects of past racial discrimination and discrimination against women. Meanwhile, colleges and universities that in the past seemed to favor white males when hiring staff and admitting students were required to take similar steps. Some people have argued that affirmative action does not result in equal treatment, but instead involves reverse discrimination. In other words, they say the affirmative action leads to discrimination against white male applicants. Faced with the question of whether affirmative action programs really do lead to fair treatment of applicants, the court took another close look at the meaning of equal protection. One school with an affirmative action program was the Medical School of the University of California at Davis. The school reserved places in each entering class for African American, Hispanic American, Asian American, and Native American students. In 1973, and again in 1974, a white applicant named Alan Bakey applied for admission and was rejected, although some members of other racial and ethnic groups were admitted with lower grade point averages, test scores, and interview ratings. Bakey took the university to court, arguing that he was a victim of reverse discrimination. The Bakey case posed a challenge for the Supreme Court. Unlike the Brown case, the justices were sharply divided. Some thought the admissions program was a reasonable way to overcome effects of discrimination. The majority, however, agreed with Bakey. The court ruled that under the equal protection principle, it was unconstitutional for an admissions program to discriminate against whites only because of their race. However, the court stated that race should be one of the factors considered if the school wished to create a more diverse student body while treating white applicants fairly. The court has also applied the equal protection principles to other issues, particularly to the debate over whether companies may treat male employees differently from female employees. May a company hire only males for certain jobs? May a company have rules that treat women differently from men? The following case illustrates how the court has applied the principle of equal protection to such questions. Ida Phillips applied for a position with the Martin Marietta Corporation in Florida. Part of the corporation's screening process was to find out whether female applicants had young children. In the corporation's view, young children take up a lot of a woman's time and energy, thus interfering with her work performance. Women such as Ida Phillips, who had 2 preschoolers, were denied jobs for that reason. When Ida Phillips was rejected for the job, she decided to take the corporation to court, where her lawyers argued that she had not been treated equally. She charged the company with discriminating against women because male applicants were not questioned about their children and were hired whether they had young children or not. After studying the case, the court ruled in favor of Ida Phillips, declaring that the company could not have one hiring policy for women and another for men. The cases you have just examined all show how the Supreme Court applies general principles of the Constitution to new situations or issues. 100 years ago, most Americans could not have foreseen that racial discrimination against a white man would ever become an issue, as happened in the Bakey case. However, the equal protection principle can be applied just as well to racial discrimination of any type. Similarly, the question of whether men and women should be treated equally in the workplace did not become a major issue until relatively recently. However, as more women have taken jobs outside the home, they have called attention to cases of unequal treatment. In response, the Supreme Court has applied the old principle of equal protection to this new situation. The general principles of our living Constitution have guided our nation for over 2 centuries and can be expected to do so in the future. Judging from past history, amendments may be required from time to time, but the Constitution's sturdy framework of principles will most likely remain intact. So that's the way it is with Lesson 12, Part 2, A Flexible Framework. By this point, you should know that the Supreme Court rules on a relatively small fraction of cases, but the decision it makes on those cases affects many people who are not part of the case. While the court upheld racial segregation laws through its ruling on Plessy v. Ferguson, it overturned that precedent following the decision in Brown v. Board of Education. Reverse discrimination within affirmative action programs was somewhat limited by the court, with the Regents of the University of California v. Bakey. And the court established a one hiring policy precedent in Phillips v. Martin Marietta Corporation. Don't forget to subscribe to my channel to have the entire catalog of civics videos available at your fingertips. Click the subscribe button and then click the follow bell to receive notifications as to when the channel is updated. Thanks for watching, and I'll catch you in class, Dragons.